Para sa videong ito, ang tatalakayin natin ay ang The Revised Penal Code, Chapter 1, Felonies. Ito ay hatid sa inyo ni Attorney Bernardo M. Luceres. Simulan na po natin. Felonies. Article 3, Definitions. Acts and omissions punishable by law are felonies, delitos. Felonies are committed not only by means of deceit, dolo, but also by means of fault, culpa. There is deceit when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Article 4. Criminal liability. Criminal liability shall be incurred, number 1, by any person committing a felony or delito, although the wrongful act done be different from that which he intended. Number 2, by any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment or an account of the employment of inadequate or ineffectual means. Here's the illustration of Article 4, Number 1. Toralba, an 8-year-old boy, was at the wrong place and time during the shooting incident. Toralba was flying a kite in the area at the time. Toralba fell to the ground upon being hit by one of the bullets fired by PO2 Cruz. Unfortunately, Toralba, who was transferred to Jose R. Reyes Memorial Medical Center, expired upon arrival thereat. While Cruz did not intend to end the life of this child, the latter's death is a crime of homicide in accordance with Article 4 of the Revised Penal Code and prevailing jurisprudence. Under Article 4, criminal liability is incurred by any person committing a felony or delito, although the wrongful act done be different from that which he intended. Accordingly, the author of the felony shall be criminally liable for the direct, natural, and logical consequence thereof, whether intended or not. For this provision to apply, it must be shown, however, that an intentional felony has been committed, and that the wrong done to the aggrieved party be the direct, natural, and logical consequence of the felony committed by the offender. It has already been established that Cruz committed an intentional felony when he fired multiple shots at Bernardo. The death of Toralba, who was hit by one of those bullets intended for Bernardo, is a direct, natural, and logical consequence of said intentional felony. The death of Toralba is an example of aberratio ictus. There are 3 scenarios under Article 4. Number 1, aberratio ictus means mistake in the blow. It occurs when an accused delivered a blow at an intended victim but hit an unintended victim because of lack of care or accuracy. Number 2, praeter intentionem means unintentional. Praeter intentionem is lack of intention to commit so grave a wrong as that committed. Number 3, error in personae means mistake in identity. Let's talk about the difference between error in personae and aberratio ictus. Aberratio ictus or mistake in the blow occurs when an accused delivered a blow at an intended victim but hit an unintended victim because of lack of care or accuracy. Error in personae or mistake in identity occurs when an accused delivered a blow at an intended victim, but it turned out to be somebody else was hit. Illustration of number 2. Number 2 of Article 4 above refers to impossible crime. This must be studied together with Article 59 of the Revised Penal Code. Article 4. Criminal liability. Criminal liability shall be incurred, Number 2, by any person performing an act, which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment, or on account of the employment of inadequate to ineffectual means. Article 59. Penalty to be imposed in case of failure to commit the crime because the means employed or the aims sought are impossible. When the person intending to commit an offense has already performed the acts for the execution of the same, but nevertheless, the crime was not produced by reason of the fact that the act intended was by its nature one of impossible accomplishment, or because the means employed by such person are essentially inadequate to produce the result desired by him, the court, having in mind the social danger and the degree of criminality shown by the offender, shall impose upon him the penalty of arresto mayor, or a fine from 200 to 500 pesos. Under this article, the act performed by the offender cannot produce an offense against person or property because, number 1, the commission of the offense is inherently impossible of accomplishment, or the means employed is either inadequate or ineffectual. What are the requisites of an impossible crime? The requisites of an impossible crime are: number 1, that the act performed would be an offense against persons or property. Number 2, that the act was done with evil intent. And number 3, that its accomplishment was inherently impossible, or the means employed was either inadequate or ineffectual. The third element, inherent impossibility of accomplishing the crime, was explained more clearly by the court in the case of Intod versus Court of Appeals. Case: Petitioner Intod, Mandaya, Pangasinan, Tubio, and Daligdig, all armed with firearms, arrived at Palangpangan's house in Catugasan, Lopez Haina, Misamis Occidental. Mandaya pointed the location of Palangpangan's bedroom. Thereafter, Petitioner, Pangasinan, Tubio, and Daligdig fired at said room. It turned out, however, that Palangpangan was in another city and her home was then occupied by her son-in-law and his family. No one was in the room when the accused fired the shots. No one was hit by the gunfire. However, Petitioner Intod was convicted of the crime of attempted murder by the Regional Trial Court and was affirmed by the Court of Appeals. Issue: whether the factual situation in the case at bar is impossible crime. Ruling: the factual situation in the case at bar present a physical impossibility which rendered the intended crime impossible of accomplishment. The decision of respondent, Court of Appeals, holding Intod guilty of attempted murder is modified. Petitioner is guilty of an impossible crime as defined and penalized in Articles 4, Paragraph 2, and 59 of the Revised Penal Code, respectively, having in mind the social danger and degree of criminality shown by petitioner. This court sentences him to suffer the penalty of 6 months of arresto mayor, together with the accessory penalties provided by the law, and to pay the costs. The impossibility of killing a person already dead falls in this category. On the other hand, factual impossibility occurs when extraneous circumstances unknown to the actor or beyond his control prevent the consummation of the intended crime. One example is the man who puts his hand in the coat pocket of another with the intention to steal the latter's wallet and finds the pocket empty. The case at bar belongs to this category. Petitioner shoots the place where he thought his victim would be, although in reality, the victim was not present in said place, and thus the petitioner failed to accomplish his end. Article 5. Duty of the court in connection with acts which should be repressed but which are not covered by the law, and in cases of excessive penalties. Whenever a court has knowledge of any act which it may deem proper to repress, and which is not punishable by law, it shall render the proper decision, and shall report to the Chief Executive, through the Department of Justice, the reasons which induce the court to believe that the said act should be made the subject of legislation. In the same way, the court shall submit to the Chief Executive, through the Department of Justice, such statements as may be deemed proper, without suspending the execution of the sentence, when a strict enforcement of the provisions of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense. The Supreme Court explained the above article in the case of Lito Corpus versus People of the Philippines. The first paragraph of the above provision clearly states that for acts born out of the case which is not punishable by law, and the court finds it proper to repress, the remedy is to render the proper decision, and thereafter report to the Chief Executive, through the Department of Justice, the reasons why the same act should be subject of penal legislation. The second paragraph is similar to the first, except for the situation wherein the act is already punishable by law, but the corresponding penalty is deemed by the court as excessive. The remedy, therefore, as in the first paragraph, is not to suspend the execution of the sentence, but to submit to the Chief Executive the reasons why the court considers the said penalty to be non-commensurate with the act committed. Under the provisions of this article, the court cannot suspend the execution of a sentence on the ground that the strict enforcement of the provision of this code would cause excessive or harsh penalty. All that the court could do in such eventuality is to report the matter to the Chief Executive with a recommendation for an amendment or modification of the legal provisions which it believes to be harsh. The second paragraph, Article 5, is an application of the humanitarian principle that justice must be tempered with mercy. Generally, the courts have nothing to do with the wisdom or justness of the penalties fixed by law, whether or not the penalties prescribed by law upon convictions of violations of particular statuses are too severe or are not severe enough are questions as to which commentators on the law may fairly differ. But it is the duty of the courts to enforce the will of the legislator in all cases unless it clearly appears that a given penalty falls within the prohibited class of excessive fines or cruel and unusual punishment. A petition for clemency should be addressed to the Chief Executive. Thank you for completing this course. Let's move on to the next.